Greetings everyone. In the last video, we spoke about the minister filing papers at the Supreme Court in Bloemfontein, which was done on Friday. We based our recording on the article by the Sunday World, which we shared with you in this platform. As I said when I was recording, that I have too many lawyers that follow my YouTube channel, and we appreciate the comments and also the guidance that they are giving us so that we have a better understanding on how these matters work. So there's a Comrade King as a royalty wrote, I quote, "Mind you, the High Court has to grant the appeal first, and in which they might not. But when the matter is with the Supreme Court, it's a different story. The minister is required to add more valid reasons, such as why the matter has to be granted a leave to appeal. And unsuccessful of granting the appeal would be considered as denial of justice. As much as the minister has also included that the circumstances of children and the ZEP holders was considered before the termination of ZEP. People were sent emails, SMS, and received letters dropped off by their gates. They just didn't want to apply for waivers. Considering the fact that they have been offered a better chance to jump into other visas, where if they qualify, they will get permanent residence. And the issue is that most Zimbabwean people don't qualify for any other visas in South Africa. Let me read the last one, the other comment. You are correct when you say most Zimbabweans do not qualify to move to other visas. Comrade Beginkosi Ndlovu then adds and says, point of correction, comrade, the appeal has to be first heard by the same judges, whether there are grounds to appeal at the Supreme Court. No, we thank you for this. Like I said, that our comments were based on the Sunday World article. We did even flight in this channel the headline of the Sunday World article that the minister filed the court papers to appeal the two judgments at the Supreme Court. We will be keeping a close eye on if it goes back to the High Court, because the suggestion here is that by some comrades that wrote in the comment section is that the minister must go back to the judges that delivered the judgment and get permission, so to speak, to appeal. So they have to firstly deal with whether there are grounds to appeal. If, of course, the judges think that there are grounds to appeal, according to what Comrade Beginkosi Ndlovu says here, it means that it is then that the minister will go to the Supreme Court of Appeal. But if then there are no grounds for appeal, say the High Court throws that case out, I do not know how that or what that will mean. But thanks for this input, we really appreciate. Then there's a comrade, Lilian Machingura, who writes, was Simba's case considered? I thought his case was thrown out. We read the judgment in the Simba Chitando. Well, it's not Simba Chitando case, he's the advocate representing African Amnesty and others. You remember that we said that the judges said that the main case is yet to be heard, but the order to amend, or the order was that the amendment of the affidavit was thrown out, and that the costs were going to be paid to the winner. The loser will pay the cost of the court to the winner. So the case of permanent residence, as far as the court dealt with it, or it did not get to the merits of the case itself, whether holders of the Zimbabwe exemption permits do have the right to apply for permanent residence. So they wanted to amend their affidavit, and the court threw that one out. So it has no material effect, as we understand, to the minister. This is why the minister is not concerned about the case of the African Amnesty at this stage, but only of the Helen Suzman and others court case and Zimbabwe Immigration Federation and others court cases. Those are the two judgments that the minister is concerned about. Then the third one, the minister is not concerned about. I wrote in our chat group encouraging people to apply for waivers. And what we got is that some people are now asking, when is the deadline for waivers? The challenge that we have, people will wait until end of November, then they realize that the deadline is just a month away, then they start again to apply. So we encourage you, if you want to move to another visa, to apply for a waiver now. But again, we know that there are others that are waiting for the outcome of the court process. As I said in the earlier videos, that application for a waiver or to move to other visas is not a forced matter. You have a democratic right. You can exercise your right to apply or not to apply. If you apply, we hope that the Department of Home Affairs is going to consider your application and give you a favorable outcome or a positive outcome so that you move to another visa, which we pray that is going to be again a positive outcome. But if you want to wait for the court process to come to conclusion, which we said might take about 3 years, again, it is your democratic right. So we do not want to be misinterpreted or misquoted to say we are forcing people to apply. We are simply saying those that wish to apply, please do so. But those that want to wait again, it's your right, you can wait. Please write in the comment section. I am Mabuto Nicholas Mapena. Like this video, circulate, subscribe to this YouTube channel. If you are on TikTok, please do follow us. Otherwise, have a great day. Goodbye.